Hello, my name's David Runciman, and this is Past, Present, Future, the History of Ideas podcast. Today, in Politics on Trial, I'm talking about one of the most notorious cases in American history. It's the trial in 1886 of the Haymarket Eight. 8 men, 4 were executed, 1 committed suicide, 2 were given life imprisonment, 1 was given 15 years, all convicted of murder, even though none of them threw the bomb or fired the guns that caused the deaths. So why were they found guilty? This is the first case that I've talked about in this series when there is more than one person in the dock, 8 people charged. In all the other trials I've talked about, it's just the one. And in this case, these are 8 relatively obscure people who came to prominence through this trial. 4 were executed and another died, 1 committed suicide. It's in relation to an event which took place on May the 4th, 1886 in Chicago, in Haymarket Square, when at a workers' rally that had been called to protest against an event that had happened a few days earlier in which 2 workers had been killed. A bomb was thrown into a crowd of policemen and protesting workers. 7 policemen died, an unknown number of workers were also killed. And this is the trial of the men who were accused of those deaths. But here are some of the things that the trial did not try to establish. It did not try to establish who threw the bomb. There were 1 or 2 moments in the case when accusations were made, one moment in the trial in particular, when a witness, when asked, pointed at one of the accused and said, "He threw it. I saw him throw it. I recognize him." But no one believed that witness. Who threw the bomb was not the question. How many people died was not the question. 7 policemen died, but the number of others who were killed was unspecified. How they died was not the question. Some were killed by the bomb, it is assumed, but some, including some of those policemen, were killed by gunfire. What happened was when the bomb was thrown and exploded, all hell broke loose. It was chaos. People were running around screaming, and the police opened fire on the crowd. Afterwards, the police accused the crowd of opening fire on them. Part of the accusation was that there was a signal given by the explosion of the bomb to armed men in the crowd to carry on firing on the police. There's no evidence of that, and it has to be assumed as at least likely that some of the police were killed in friendly fire. Policemen shot other policemen by accident. But none of that was established or even attempted to be established in the court case. Instead, the question was, as one of the prosecutors put it in his speech, who abetted this event? Who inspired it? What lies behind it? Not who did it, but who triggered it. And in asking that question, the net was cast pretty wide. And so the question in this trial was who fell into that net, the net of people who were the abettors, the enablers of this event. But also, what kind of a net was it? Or to use a more contemporary term, what kind of a network are we talking about here? What network of people inspired this event? And the answer was that it was a conspiracy. And so this trial, to use another contemporary term, was one vast conspiracy theory. The reason these events happened in Chicago is twofold, really. Chicago had become a hub for workers' agitation, for violent workers' confrontations demanding labour rights through the 1870s and the 1880s. One reason for that was the campaigning cause of many labour unions in this period was the 8-hour working day. They wanted workers to have the right to work only 8 hours. In an economic climate where workers often were expected, required to work 10 hours, 12 hours, 14 hours, 16 hours. Ridiculous shifts in terrible conditions. The 8-hour day was the rallying cry of the labour movement. And the first state to enact an 8-hour working day in law was Illinois. Just after the Civil War, it happened in 1867. It went on the statute book. And it almost immediately became a dead-letter law. It was never enforced. Employees ignored it. They continued to demand that their workers work far longer under terrible conditions. And when the workers protested, went on strike, tried to demand their rights, the police and other enforcement agencies sided with the employers, not with the workers. And so in Illinois, the fight continued, and the workers were enraged by the fact that the previous victory that had been won was hollow. And this was a fight not just between labor unions and police. It was an exceptionally violent time in which a lot of what happened came under the guise of various militias. The employers also employed agencies like Pinkerton's, the detective agency, but also in this age there to provide muscle, to bang heads together when needed. But other militias too. Many of the businessmen in Chicago basically organized far-right militias whose job was to intimidate the workers, and the workers responded in kind. Labor unions and others organized their own armed militias. You could see on the streets of Chicago in the 1870s and the early 1880s, men marching with guns who were neither soldiers nor policemen, but either left or right armed militias. Illinois tried to clamp down on this. Laws were passed outlawing these militias, but again, they were enforced against the workers, not against the employers. This was the climate in which the Haymarket bombing and trial took place. But the other reason that Chicago and Illinois were a hub is that many European immigrants went to Chicago, many of them from Germany, and many of them had been involved in workers' and labor struggles back home, or at least came with ideas about how to pursue this fight. Socialists from Germany, communists from Germany, anarchists from Germany. Anarchists, probably the most radical of them all. Men who didn't just believe in fighting for workers' rights, but wanted to blow up the entire system. And these men published newspapers and magazines to promote their ideas. A newspaper, which was central to the Haymarket case, called the Arbeiterzeitung, was published in Chicago. And it advocated armed resistance on the part of the workers, taking the fight to their oppressors using physical force. Perhaps the most notorious of the magazines published at this time was called Alarm. It was an anarchist magazine, and its publisher was also a recent immigrant to Chicago, to Illinois, but he didn't come from Europe. He came from Texas. He was a man called Albert Parsons. He arrived in Chicago with his wife, Lucy Parsons, who co-edited Alarm with him and wrote some of the articles in it. Lucy Parsons, a remarkable person in her own right. Albert Parsons was white. Lucy Parsons was black. So they were also an unusual couple in an age where mixed-race relationships were scandalous. And many of the things that Parsons was accused of at the time of the trial were accusations that were also thrown against his fellow defendants: anarchism, socialism, violence, terrorism. But Parsons was also accused, it's an ugly word, it's so ugly it's almost impossible to say it. He was also accused of miscegenationism. He was a miscegenationist, a mixer of the races. And in their magazine, Albert and Lucy Parsons had one word to sum up their cause. There was one word that described what they thought was the weapon that the workers had at their disposal to take to the enemy, the class enemy, the official enemy, the established enemy, not just the employers, but the entire structure of the state. And that word was dynamite. Throughout Alarm, article after article reminded the workers to not just arm themselves, but to use dynamite, literally to blow up the system. That's what was being advocated here. Violence against the system to destroy it. This came to a head in 1886 because another campaign had been launched to fight for the 8-hour day. It was a nationwide campaign. A national strike was called for May the 1st, 1886, to take the case for the 8-hour day at a national level to the employers. And in various parts of America, this produced violent confrontation. Among the most violent happened in Chicago at a factory called the McCormick Reaper Factory. The Reaper was a kind of combine harvester. It was a piece of agricultural equipment. The McCormicks made it. The McCormicks made the Reapers, and the workers built them in the McCormick Reaper Factory. The McCormicks were ruthless employers, brutal, ruthless employers. When the workers demanded the 8-hour day in the McCormick Reaper Factory, they were locked out, and non-union workers were brought in to work the factory while the official workers were kept on the outside. It was a very, very tense atmosphere around the factory. Some of the non-unionized workers, as the build-up to May the 1st happened, also started to demand an 8-hour day. And the McCormicks crumbled, and they gave them what they wanted. That is, they said non-union workers can have the rights that the unions are demanding, but the unionized workers are out. So in this factory, there were men on the inside working who'd been promised the thing that the men on the outside had been striking for, and the men on the outside were understandably enraged. And on May the 3rd, there was a confrontation. As men left the factory, the picketing strikers outside started jeering them and throwing rocks at them, and the police opened fire on the crowd. 2 men, at least 2 men, were killed. It provoked outrage in the city, and it provoked outrage among many of the organizers of labor resistance, including many of those, like Albert Parsons, who'd been advocating armed resistance. And another man too, August Spies, who was the editor of the Arbeiterzeitung. And he organized a rally for the next day, May the 4th, to protest against what had happened at the McCormick Reaper factory. He produced a leaflet that was distributed around the city, telling the workers, among other things, to arm themselves. There was a meeting on the evening of the 3rd of May at a place called Grief's Hall in Chicago, where a group of militant agitators, including Spies and Parsons, were present, others too. And there was wild talk. There were witnesses who testified to what was said, and no doubt these men were angry, and they were talking the talk. They'd gone in print advocating violence, and they were talking about what might be necessary if this really did blow up. This was a kind of proxy civil war taking place on the streets of Chicago. Militia were involved. A lot of people were carrying guns. The police were murdering the workers. What were the workers going to do? There was talk of, if necessary, firing on police stations. There was talk of fighting back if this got out of hand. But there was also talk of the rally the next day. Spies, who issued a leaflet asking the workers to arm themselves, then withdrew that leaflet and replaced it with a more emollient version without the call to arms, because he thought it would put off many of the people who wanted to attend, who might be frightened that the event would explode in violence. So he tried to tone it down. Parsons spoke at the Haymarket rally. Others spoke too. A man called the Reverend Samuel Fielden spoke at the rally. Spies spoke at the rally. The mayor of Chicago, a man called Carter Harrison, attended the rally because he had heard that it might be incendiary, that it might be violent. And he watched the speeches, and after a while he went home because he concluded that it was not going to be a violent event. The speeches were actually, by the standards of the time, relatively moderate. Parsons, Spies, Fielden, and others did not call for an armed uprising. They demanded that the workers demand their rights, that they stand together. They were calling for organization, for solidarity, for resistance. But this was not a criminal event. And Harrison went home. But one of the speakers right at the end of the day did use a phrase which was that the workers should be willing to throttle the forces of law and order if necessary. And that was enough for someone to tell the chief of police that there were men at the Haymarket rally demanding an attack on the police force. And so the police came to the rally to break it up right at the end, after almost all the speeches had happened. And some of the people who had spoken, including Parsons, had left, though Lucy Parsons and their children were still there. The police came to break up a rally that now consisted of just a few hundred people because most had gone home. And at that point, a bomb was thrown. It landed in the police. It went off. There were dead bodies. The police opened fire. There were more dead bodies. There was chaos. And as a result, by the next day, the newspapers in particular, but I think it's fair to say public opinion, was demanding that something should be done to stop this anarchist, bloody chaos on the streets of Chicago. And not just Chicago newspapers, from the New York Times all the way through to the West Coast. The demand was that this red terror, this anarchist bloodshed, had to be stopped. Somebody would have to be held to account for this. So all sorts of people were rounded up. All sorts of people were accused. One of the men rounded up, a man called Schnaubelt, may well have been the man who threw the bomb, but the police let him go and he fled town. So he was never put on trial. It may have been him. It may not have been him. Another man who was rounded up, a man called Seliger, and was accused of being part of the conspiracy that lay behind the Haymarket bombing. He agreed to turn state's evidence, including testifying to what was said at that meeting the night before, testifying that these men were planning violence in some form or another. In the end, 8 men were put on trial for these murders. One was a man called Louis Ling. He was a bomb maker. He was known to be a bomb maker. He was part of this anarchist community, and he was one of the people who made the dynamite. Another was the Reverend Samuel Fielden, who had spoken at the rally, a known radical. Parsons was one of those charged, August Spies, a man called George Engel. He'd been at the meeting at Grief's Hall. Another man called Adolf Fischer, also at the meeting at Grief's Hall. Michael Schwab, who was assistant editor of the Arbeiter Zeitung. And finally, a man called Oskar Niebuhr, who had not been at the rally, who had not been at the meeting, who was nowhere near the event, but was the office manager of the Arbeiter Zeitung. In his apartment were found some of the leaflets that had called workers to arms the next day, and he was in possession of a weapon. But most people in Chicago were in possession of a weapon. These were the men who were put on trial for the Haymarket murders. The trial was a huge event, a huge media event, national attention on this. The demand for something to be done was real. It was live. It could be felt on the streets. It was a very tense time in Chicago. There was a crackling air of violence around this event. The trial had all sorts of moments of drama in it, starting with the question of jury selection. So there was enormous prejudice around this case. The newspapers had been demanding the deaths of these men from the moment that they were arrested. And juror after juror was asked whether or not they had already formed an opinion about the guilt or innocence of these 8 men. The jury pool itself, a big jury pool, nonetheless had already been skewed by the fact that it had been decided by the bailiff of the court that this couldn't be a fair trial if any of the jurors were recent immigrants, because they would be prejudiced in favour of the defendants. Of the defendants, 6 had been born in Germany. These were first-generation immigrants. So the jury couldn't consist of recent immigrants. It couldn't consist of anyone involved in the labour movement. Never mind agitators, but anyone even involved in labour politics. It had to be solid, upstanding citizens of the city of Chicago. One after another, potential jurors were asked, have you formed a view of this case? And they said yes, yes, yes. We already believe these men are guilty. It was going to be very, very hard to form a jury. One after another, the defence rejected these jurors as prejudiced. But some of the jurors were taken away and coached and told to still insist, when questioned, that they were capable of having their minds changed. And so in the end, the jury consisted of a series of men. After multiple objections by the defence were launched against prospective jurors, the final 12 consisted of men, some of whom had said under questioning they had already formed a view of the case, but nonetheless, when asked further questions, that they were capable of revising that view, and that was thought to be sufficient. That was the jury. The next moment of drama happened because the arrest warrant that had been issued for Parsons caused him to flee. The other 7 men remained and were rounded up one by one, some a few days after the attack. But Parsons left town. And it looked like when the trial started that his chair would be empty. He was one of the 8 accused, but he wasn't there. The defense lawyer for the 7 got message to Parsons begging him to come back, arguing that his absence made the other 7 look guilty. They hadn't fled. They were willing to face the charges, but if he wasn't willing to face the charges, it would be much easier for the prosecution to tar them all with that brush. It didn't seem likely that Parsons would respond to this request because returning to face trial under these conditions was not a guaranteed death sentence, but it risked a death sentence. And yet, at the start of the court case, in full view of a packed courtroom, hundreds of people there, journalists from all over the country and around the world, Parsons walked in and took his seat beside the other 7. An act of extraordinary courage, maybe of foolhardiness, but he returned to face the charges. The evidence as it was presented was often very sensationalist. As I mentioned, at one point, one of the witnesses pointed to Spies, the editor of the Arbeiterzeitung, and said he threw the bomb. Spies had been on the platform. He had been one of the speakers. He was still standing on the platform when the bomb went off. He didn't throw the bomb. But that moment caused the entire courtroom to explode in uproar. The judge threatened to clear the court if people didn't settle down. There was other dramatic evidence. At one point, one of the witnesses argued that it was known among the anarchist community in Chicago that there was a code word, a trigger word that was designed to call them to arms, to violence, and that it would appear in the Arbeiterzeitung. If the word Ruhe, meaning peace or calm, appeared frequently in the columns of the Arbeiterzeitung, a newspaper that was not devoted to advocating peace or calm, that was the word that told people to attack the police. The word did appear in the newspaper the day before the attack. Therefore, the conspiracy had been revealed, the Ruhe conspiracy. Testimony was given about what was said at that meeting at Grief's Hall. Other witnesses claimed to have seen things on the day involving the men in the dock. All sorts of wild accusations were made. Another witness who was called by the defense was the mayor of Chicago, Mayor Carter Harrison. He testified that he had been at the rally, he had heard the speeches of men like Parsons and Spies, and he had left because he realized nothing criminal was taking place. And if the police came after he left, that was on them, not on him. In the summing up, the prosecution made the case against these 8. That is the case that is often made in political trials. Earlier in this series, I've said it's almost one of the defining characteristics of a political trial that at some point someone will say, you can't acquit them because if you do, you'll just empower them. It happened at the trial of Socrates. One of his accusers said, we've reached the point now that we've put him on trial. It doesn't really matter anymore if he is as accused. We can't let him go because think how intolerable he will be if we now tell him that he's got away with it. It happened at the trial of Joan of Arc. The case was made that she couldn't be released because having been charged to acquit her would simply make her their worst nightmare. It happened in the trial of the Haymarket 8. The prosecutor said to the jury, this is a difficult decision for you. Everyone was aware that there was no evidence that these men had thrown a bomb or pulled a trigger. But the prosecutor said to the jury, tough as this decision is, it is clear what you have to do, because just think what will happen in this city if you acquit these men. These men who you have heard, and evidence was given of the things they had written in their newspapers and the things they might have said. These were men who had advocated, in general terms, armed resistance by the workers. If you acquit them, what you will get is an armed uprising of the workers. The anarchists will think they have won, And the prosecutor said, the vermin, the rats of anarchism will swarm the streets of Chicago and the blood will run. So you now have no choice in this case. Once the trial started, effectively, the prosecutor is saying it had to be a foregone conclusion, or else you, the jurors, are responsible for what happens next. The jury retired, and it didn't take them long. They came back and they convicted all 8 men. Everybody knew that you might think the case against all of them was weak or weakish, but the case against Oscar Niebuhr, the office manager, the man who hadn't been at the meeting or the rally, was weakest of all. The judge sentenced 7 of the men to death and Niebuhr to 15 years in jail. So 7 were slated to hang. And that, in a way, is when the fight really started. These men tried to defend themselves in court. Parsons came back at the behest of their lawyer, one of their lawyers, to defend himself in court. But it was not just an uphill struggle. It really was almost impossible in that climate, with that jury, under those conditions, with those witnesses, to mount a winning defense. Once they'd been convicted and sentenced to death, a massive campaign was launched, an international campaign, to demand that the governor of Illinois pardon them, or at the very least, commute their sentences. Signatories to this huge petition of hundreds and hundreds of thousands of people included many from Europe, many from Germany, a large number of people from Ireland. Chicago had a big Irish community, but in Ireland, the question of the armed struggle was also live. But it wasn't just people involved in that struggle who signed this petition. A couple of well-known Irish émigrés signed it too, not émigrés to the United States, but émigrés to England. George Bernard Shaw signed it. Oscar Wilde signed it. It had no effect. The governor of Illinois was in no mood to pardon these men. He did respond to 2 pleas for clemency, however. 2 of the 7 men who were condemned to death wrote to the governor. Samuel Fielden was one, Michael Schwab was the other, asking for clemency. And he responded by commuting their sentences and instead giving them life imprisonment. One of the other men also wrote to the governor. George Engel wrote and said, "I don't want your clemency. What I want is the workers to have their rights." His sentence was not commuted. The governor was not going to pardon these men, so the case was taken to the Illinois Supreme Court on appeal, on the grounds that this was not a fair trial, and these men had been unjustly convicted. The evidence against them was not compelling. The conspiracy was imagined. Nothing that had been said in the court placed them at the scene in a way that meant that they were directly responsible for what had happened. And the Illinois Supreme Court delivered its verdict in a huge judgment. It goes on and on and on, page after page after page, going through all of the evidence, all of the accusations and counter-accusations. It is an extraordinary document. It starts, the very first thing it addresses is the question of the bomb itself, with a kind of lurid description of what this bomb looked like, how it was made. If you've seen any cartoons of anarchists in the 19th century or the early 20th century, they're always drawn the same, men in coats carrying a bomb that looks like a football with a little bit of cord sticking out of it, the charge sticking out of it, which is lit at the end and fizzing, like a little round black ball with a little bit of cord sticking out that's on fire. That's what an anarchist bomb looks like. And in the Supreme Court verdict on this case, they go to great lengths to describe the bomb in these terms. Effectively, they're saying it looked just like one of those anarchist bombs. And Louis Ling, a bomb maker, made bombs that looked like that. He was known to have what they called, although this is slightly over-egging it, a bomb factory. It wasn't a factory. But he did make bombs in his back room. And they looked like this, like footballs that you could light. QED, Louis Ling, was the bomber. There was no actual evidence that it was one of his bombs, but it was enough to describe it It was an anarchist bomb, and we all know what they looked like. The Illinois Supreme Court went in great detail into the Ruha conspiracy, the idea that this word appearing in a newspaper signaled that the workers had been called to arms. Prime your bombs. Get your guns out. It's time to attack. The word appeared in the newspaper. The attack happened the next day. It was a conspiracy. They describe at great length the meeting at Grief's Hall, the fact that many, not all, but many of the accused had got together the evening before the attack, the day on which 2 workers had been killed at the McCormack Reaper plant, men who were known to have advocated violence, and they sat round a table and they talked the language of violence, the language of resistance. They were wild with fury and rage. That was a conspiracy. On and on and on the judgment goes. The jury was fair. The witnesses were reliable. Some of the witnesses had seen things. They wouldn't have said they'd seen things if they hadn't seen things. The phrase that's sometimes used of American politics is that it is riven through with what's called the paranoid style, term invented by the historian Richard Hofstadter in the second half of the 20th century to describe essentially the atmosphere of McCarthyism. The paranoid style is often associated with demagogues like McCarthy, wild politics, fringe organizations, with conspiracy theorists, with people alone in their rooms coming up with these crazy visions of what America is. The paranoid style is usually assumed to be something that you find in the dark places of American political life. But the paranoid style is also sometimes the official language of American politics. The verdict of the Illinois Supreme Court on the Haymarket 8 was paranoid. It was a conspiracy theory that they mounted to justify the convictions. It's also often sometimes thought of conspiracy theorists that they reveal themselves by the erratic, crazy nature of their communications. Conspiracy theorists will hand out to you smudged leaflets with their mad ideas on them. They will post crazy videos on YouTube. You'll see them in the darkened places, scrawling on the walls. These are the people who signal they can't be trusted by the fact that they don't even know how to mount a plausible argument. Not true. Many conspiracy theorists want nothing better than to mimic the language of the official thing that they are trying to undermine. Conspiracy theorists who write long history books often have more footnotes in them than conventional history books. They go deeper into the evidence. They spend more and more time trying to cite every single tiny detail that shows their case. The judgment of the Illinois Supreme Court was that kind of conspiracy theorizing. These judges left no stone unturned. Nothing in the trial was allowed to pass without comment. And every comment that they passed tied it together. I've read this judgment. I don't know how long it is because I've read it online, but it felt like it was as long as a book. And yet, at the end of it, I think I could sum it up in a single sentence. The Illinois Supreme Court concluded of this case and these convictions that there is no smoke without fire. And therefore, these men were guilty as charged. The conspiracy was real. So then the case was taken to the United States Supreme Court. And the United States Supreme Court did not issue nearly such a long judgment. Effectively, the United States Supreme Court said that these verdicts can and should stand because there were no federal issues at stake. This was a matter for the state of Illinois. The crimes took place in Illinois. The trial took place in Illinois. The Illinois Supreme Court had passed its judgment. There was nothing for the Supreme Court to add. You might think there were federal issues at stake in this case, constitutional questions at stake in this case, because it did touch very directly on freedom of speech. These men were convicted, many of them, for what they had written, for a pamphlet that had been produced, or for articles they had written in newspapers or magazines calling for the use of dynamite, incendiary pieces of writing, But an incendiary piece of writing is not the same as an actual explosive. Writing about dynamite is not the same as blowing up policemen. And these questions were to be acute in the 20th century, and in a series of Supreme Court judgments, starting in the early 20th century, on these very issues, whether men who had produced leaflets calling for armed violence, effectively for terrorism, could be treated as terrorists. And the Supreme Court came to the view that they could not be treated as terrorists, that their First Amendment rights protected them from the charge that writing it was the same as doing it. And the men who were accused in the cases that changed the law in 20th century America were Bolsheviks. They were Russian immigrants to the United States, writing newspapers and magazines, just like in Chicago in the 1870s and 80s. But this is in First World War and post-First World War America. The Supreme Court did not say of those cases that there were no federal issues at stake. But in 1886, the Supreme Court was not interested. And so the convictions were allowed to stand and sentence would be passed. And it was passed. More than a year after the end of the trial in November 1887, 4 of the 8 were executed. 2 had had their sentences commuted. 1, Oscar Niebuhr, had only been sentenced, I say only, to 15 years. Parsons was hanged. Spies was hanged. Engel was hanged. Fisher was hanged. Louis Ling, the bomb maker, was not hanged because he had managed to smuggle into his cell some explosive, and he blew himself up, or rather, to give the ghastly detail of it, he managed to hold some explosive to his mouth, and he blew the front of his face off, and he lived for 6 more hours before he died. The other 4 were hanged. They were brave. 3 of them made statements on the scaffold, defiant statements. But none of it did any of them any good. Lucy Parsons went to visit her husband, Albert Parsons, just before his death. The international campaign, which, among other things, focused on the fact that these were family men who had done nothing that would count as murder outside of a prejudiced and prejudicial trial. That campaign did nothing. And the fight moved on. These men became martyrs to the cause. They were inspirational for many people around the United States. The most famous of all American anarchists, Emma Goldman, was inspired to take up the cause by the case of the Haymarket 8. American labor relations remained astonishingly violent through the rest of the 19th century. Much more violent clashes than took place at the McCormick Reaper Works took place in other places in Pennsylvania, in New York. Scores of people killed in violent clashes between the police, between Pinkertons, between armed militias, and the unions, the workers, the strikers. Nothing was resolved by this case, one way or the other. And in fact, nothing was resolved in the fundamental issues of American labor relations until a new politics emerged in the 20th century that took it beyond street violence, violent strikes and the violent repression of strikes, and also took it beyond European revolutionary and anarchic politics and took it into legislatures, took it into the federal government, progressivism, and then New Deal democratic politics eventually gave the workers their rights. But it took more than a generation for it to happen. There are 2 remarkable postscripts to the case of the Haymarket 8. The story is not complete if it just ends with their deaths and, in a sense, the fight moving on. One involves a man called John P. Altgeld, who became the governor of Illinois in 1893. And in one of his first acts, he pardoned the Haymarket 8, which meant the 3 who were still in jail were released. He pardoned them in a verdict which is not as long as the Illinois Supreme Court verdict, but is pretty long. But it's a much clearer document. It's better written. There's much less legalese. He writes it more like a politician and less like a lawyer. And he boils his case for a pardon down to two basic strands of argument. He doesn't really go into all of the ins and outs of the evidence and the this and the that. He blows apart the conspiracy theory in two ways. First of all, by focusing on the jury selection. He goes through the transcripts of the men who were summoned for jury selection, and he cites some of the transcripts of men who were accepted. In the Illinois Supreme Court judgment, it says that the defense have no grounds for complaining about the jury selection because they did not use up all of their possible objections. After hundreds and hundreds and hundreds of jurors had been rejected, in the end they effectively gave up and they took what they could get, which was men who at least were willing to say that they would try and go into this case with an open mind. But Altgeld, in his pardon judgment, lists what that meant. So here's one example of an exchange of a juror who was accepted on the jury for this trial. Question: is yours a decided opinion as to the guilt of the defendants? Answer: it is a decided opinion. Yes, sir. Question: your mind is pretty well made up now as to their guilt or innocence? Answer: yes, sir. Question: would it be hard to change your opinion? Answer: it might be hard. I cannot say. I don't know whether it would be hard or not. That man served on the jury in the Haymarket case. It was enough to say that it might or might not be hard for me to give up my view that these men are guilty. So there were grounds enough for deciding that these convictions were unsafe. The jury was clearly prejudiced. But Altgeld doesn't stop there. He explodes the conspiracy theory in a different way, in a less legalistic way, a less technical way. He takes the fight to the conspiracy theory in its own terms by saying this, and he says it again at great length with lots of examples. There were many examples given of the questions that were put to prospective jurors, but also he gives many examples of his second line of argument, which is, we don't know who threw the bomb. And this was caused by one man throwing a bomb into a crowd of policemen, some of whom were killed, others of whom opened fire, killing others in the process. It was all triggered by a bomb. We don't know who threw it, and we don't know what motivated that person. The case against these men is that it was motivated by their words and deeds prior to the event itself. They had said things in print. They had produced pamphlets. They had organized this meeting. They had organized campaigns. They had created an atmosphere of violence. And out of that atmosphere of violence, one individual was inspired to act. And that is enough, that inspiration, to convict these 8 men. That was the case made by the prosecution. And Altgeld says, if you take that line of thinking seriously, the real question is, what was likely to have provoked the bomb thrower? That's what we're asking. We're not trying to identify the bomb thrower. We're having to speculate, in the terms of this case, what was the cause, the provocation. And Altgeld says, on the balance of probability, it is more likely that this man was provoked by the police, because the record of the preceding years, not days and weeks, but years, of police brutality, of police violence, of police mistreatment of prisoners, of police corruption, was such that if you were trying to guess what would send someone so crazy, so mad, make them so enraged that they would throw a bomb into a crowd of policemen, it is the police themselves who provoked that. Now, Altgeld's not saying, therefore, the police should be charged with this crime, because that would be absurd. What he is saying, and I'm massively paraphrasing what he said, because he lists example after example of police violence and police brutality. But what he is saying is, if the case here is that we've got to guess what the provocation was, the provocation is much more likely to have been police violence than worker violence, in which case not the police are guilty as charged, but there is clearly no case, because no one in a million years is going to put policemen in the dock for this. And if you're not willing to put policemen in the dock, which we aren't, and Altgeld certainly isn't, he's not insane, nobody can be put in the dock for this. He does genuinely blow up the conspiratorial mindset of the prosecution, of the newspapers, of the Illinois Supreme Court. You cannot go down this road of speculating about the network of behavior and actions that provoke an individual act of violence, because if you do, you will find yourself in an absurd position. Here, he's almost saying, is the absurdity. The police did it. And incidentally, though he doesn't need to say it, though he hints at it, the police probably did do some of it. Of the killing on that day, it's much more likely that more people died from police bullets than from the bomb. The other extraordinary postscript to the case of the Haymarket 8 is the story of Lucy Parsons, the wife, then the widow, of Albert Parsons, one of the 4 men who was hanged. Lucy Parsons lived, almost amazingly, for another 56 years after this case. She lived through to the Second World War, and she became a well-known activist in her own right. Anarchist, campaigner, involved in the workers' movement. She became a friend for a while, or at least a colleague, of Emma Goldman in the anarchist movement, the woman, Emma Goldman, who'd been inspired by her husband's mistreatment to become an anarchist, got to know Albert Parsons' widow, and they fell out. They had a ferocious falling out many, many, many years after the Haymarket case. And they fell out not over the case, not over anarchism, not over political tactics, but over the question of free love. Emma Goldman believed in free love. She was the most notorious advocate of free love in early 20th century America. And Lucy Parsons, rather touchingly, believed in marriage. Lucy Parsons, who had made this extraordinarily courageous marriage to this man, Albert Parsons, by whom she had children and raised after his death, was not going to go down the free love anarchist route. She was not that kind of anarchist. And right at the end of her life, she wasn't even an anarchist at all. She joined the Communist Party in 1939. She held on until 1939. Anarchism and communism are not the same thing, but in the end, she recognized that anarchism was finished and change would come through communism, or so she believed, just before she died. But the other remarkable thing about Lucy Parsons is that if the case against her husband and the other men is that they were involved somehow in this terrorist act because of what they had written, because of the organizations and publications that they were involved with, because they were present on the day, they were there at the rally, they were in the crowd when the bomb went off. Well, that was not true of Albert Parsons. He was not there when the bomb went off, but as part of his defense, he said, "Do you think I would have been responsible for this? Because I knew that my wife and children were there. Do you think I wanted them to be the victims of a bomb attack?" Lucy Parsons was there. But more than that, Lucy Parsons was the co-publisher, the co-editor with her husband of Alarm, the most incendiary of all of the magazines. And there is a question as to why Lucy Parsons wasn't charged. If you're going to cast the net wide enough to include the people who were behind the most incendiary pieces of writing that were being published in Chicago in the run-up to this notorious act of terrorist violence, that would have to include Lucy Parsons, because she probably published the most incendiary article of them all. It was published in 1884, so 2 years before the bombing, the Haymarket bombing. It had a very unthreatening title, this article. It was called Tramps, and it was a letter by Lucy Parsons, signed by Lucy Parsons. She puts her name at the bottom of it. The sign-off is dedicated to the Tramps by Lucy E. Parsons. It's a letter to tramps sympathizing with their plight. Tramps here mean the destitute, the people who have been utterly impoverished, who have lost everything. Family men who can no longer support their families, can no longer support their children, can no longer feed their children, tramping, looking for work. The lowest of the low, the most vulnerable. And Lucy Parsons says to the tramps, I completely understand the awfulness, the hopelessness of your situation. And she says, and I understand why it is the case that people who find themselves at this level of destitution are so hopeless, they conclude they must take their own lives. Suicide is the way out. It is at least one of the ways out. And she does not discourage it. She does something else. I'm just going to read this bit. This is Lucy E. Parsons, 1884, Tramps. Speaking to people who are considering committing suicide, she says, is there nothing you can do to ensure those whom you are about to orphan against a like fate, that is, destitution? The waves will only dash over you in mockery of your rash act, but stroll you down the avenues of the rich and look through the magnificent plate windows into their voluptuous homes. And here you will discover the very identical robbers who have despoiled you and yours. Then let your tragedy be enacted here. Awaken them from their wanton sports at your expense. Send forth your petition and let them read it by the red glare of destruction. Thus, when you cast one long, lingering look behind, you can be assured that you have spoken to these robbers in the only language which they have ever been able to understand. She signs off, not dedicated to the tramps by Lucy E. Parsons, but before that, learn the use of explosives, ! Dedicated to the tramps. What is she calling for here? She's calling for suicide bombers. That's what this is. Tramps was a 2-page article published in Alarm saying that the workers needed to start blowing themselves up in the avenues of the rich. Now, the Haymarket bombing was not a suicide bombing, at least so far as we know. The bomber was never found. But we're pretty confident it wasn't a suicide bombing. Nonetheless, Lucy E. Parsons was as incendiary as anyone in America, in all of America, in the 1880s. And she wasn't charged. Why was the woman who was calling for suicide bombing not charged, and the man who had never written anything, who was just the manager of the office where the newspaper was printed, the newspaper in which supposedly one word had triggered the signal to launch the attack? Why was he charged and Lucy E. Parsons was not charged? It's because they knew that charging a black woman who wrote these kinds of articles would make them look ridiculous. If they cast the net wide enough to include her, the idea that she could have inspired this act would have ridiculed their case. So they found men they thought they could pin it on because they fitted the model or the mold of the anarchist agitator. A black woman from Texas did not fit that mold. But the fact that they didn't charge Lucy E. Parsons because they knew it would look ridiculous, even though she had written things that were wilder than anything that her husband or the other men wrote, that she was probably angrier, that she was probably willing to countenance worse violence than any of them. The fact that they didn't charge her because they knew it would make them ridiculous is all the evidence that you need, that they knew that the case that they were making was ridiculous. Next time in Politics on Trial, it is 2 trials for the price of 1, both involving the Irish politician Charles Parnell at the end of the 19th century. In one, he was cleared of involvement with terrorism. In the other, he was convicted, including in the court of public opinion, of being an adulterer in a divorce case. And that one changed the course of British and Irish history. Coming soon, a new occasional series with regular PPF contributor Robert Saunders. We're going to call it Now and Then with Robert Saunders, and he and I are going to be discussing political anniversaries and their significance for the politics of today. Do join us for all of that. This has been Past, Present, Future.